Good. Ladies and gentlemen, good afternoon. I'm Bob Clifford, and welcome to the 5th annual Clifford Law Offices Continuing Legal Education Program. You know, as president of the Chicago Bar Association and as the Illinois State Delegate to the ABA House of Delegates, I've had the privilege and opportunity to participate in and believe in the view that we as a profession have an obligation individually to raise the practice of law, the quality of the practice of law, and whether it be civility or goodwill among our lawyers or increasing competency in the profession. So I hope that this particular program is a timely one for all of you and that it is one that is very useful to you and that this is a step in the right direction. Ethics issues in mediation. Many programs that we attend and that I've sponsored in the past have tended to focus on trial practice, and yet given the statistical number of cases that settle 95% and above, I thought it would be important to talk about the ethics of mediation and that there are certain rules and sources of obligation that are often overlooked and not talked about. Many lawyers are familiar with the process of mediation, but they're not necessarily familiar with or sensitive to the ethical issues that are associated with it. And make no doubt about it, mediation is here to stay. I can recall over 25 years ago that I said on a program, an ABA program, that mediation was a euphemism for taking less money. But nevertheless, that it's here to stay, and I'm one of the old dinosaurs that would rather go to trial as opposed to mediator. At least I say that, and hopefully the numbers go up. But so this afternoon, to familiarize you with some of the concerns that lawyers need to have, we've got a great panel that I'm proud to present, two esteemed colleagues to us at the bar and two very, very long-time friends of mine, dear friends of mine that I'm so happy to be with. Judge Stuart Nudelman, who's the former Cook County Circuit Court judge that is well known to so many of you, and he's a highly successful mediator with ADR Systems, and Professor Katheryn Dutenhaver, who's the director of DePaul University College of Law Center for Dispute Resolution. Their CVs are extraordinarily impressive, and you can read about them both in the materials that are attached to the program, but on our website, cliffordlaw.com. We also have written materials that are included in today's packet of information, which will, after the program, will be posted on my firm's website. If you download them from the website, you do not get CLE credit. You can only get CLE credit if you're logged into this actual program. But they include the PowerPoint slides from today as well as a couple of articles that I think you'll find of interest. So today, if you have any questions for those of you who are in the room, please raise your hand, and there are spotters who will hand a microphone to you. For those of you who are listening on the web, you can click on the Participate tab to submit your question, and it will come through the desk, and it will be read by one of the staff here. So thank you for joining us. Permit me to turn the program over to a lady for whom I have the utmost respect, Professor Dutenhaver. The way we're going to do this, I'm going to initially ask her to speak to us about some of the sources of obligation, but we're also going to be presenting to you scenarios, hypotheticals, that we will go through and see how those hypotheticals play into the sources of obligation, the rules of mediation, if you will. And so, Professor Dutenhaver, you have the floor.
Thanks, Bob. The sources of obligations come primarily in a group that are binding obligations on lawyers, and the other group that are non-binding but guidelines on lawyers. And as we go through the materials today, we have these with each of the hypotheticals, and we'll be able to guide you through that. The Uniform Mediation Act, which was adopted by the Uniform Commissioners back in 2002 or 2001, was adopted in Illinois in 2004. That's a source of obligation that is an enforceable source. And it can be, the provisions of the Uniform Mediation Act in Illinois can be modified by agreement of the parties. The other main source of obligations that we have are the Illinois Rules of Professional Conduct. And in 2010, provisions were added that specifically talked about lawyers being third-party neutrals, being mediators, and some of the other provisions that apply to that. The third source that is cited most often, which are not binding, are the standards of models of conduct that were put together by a joint committee of the American Bar Association, the Association of Conflict Resolution, and the American Arbitration Association. And those guidelines is a list of very helpful ways of understanding what is expected of mediation. As you probably know, mediation is so new that the development of law in the field is just getting started. So there's very little case law. There's also ethical opinions that have come from the American Bar Association, a few that have come from the Illinois State Bar Association, and we'll be making reference to those as we go along.
Before I turn to the first hypothetical, I do have a question that possibly Judge Nudelman might address, and that is, should lawyers and the mediator approach mediation with specific goals in mind?
The knee-jerk answer to that question is yes, and the answer generally is to settle a case. I will tell you that some of you may have been involved in mediations where that was not the ultimate goal. More often than not, in commercial mediations or complex tort mediations, the first mediation session may not be for the purpose of settling the case, but may be for other purposes, limiting the issue. Settling disputes in discovery is often done in mediation settings. In commercial mediations, you may have 4 or 5 sessions before you reach a point where we're talking about the settling of the case. So there are different goals that different people have for a mediation. What should be standard is that both parties approach the mediation with the same purpose in mind. For one party to enter a mediation assuming they'll settle the case, and the other party entering the mediation not for that purpose, well, there's a problem. And again, we as mediators try to solve those problems if we can in pre-mediation discussions with the parties. Mediations are not arbitrations, they're not trials. We make no decisions, so ex-party communications are not really an issue for us. So pre-mediation contact with the litigants, with the attorneys, gets to be very important in those situations.
Well, then let's turn to our first hypothetical that I'll pose to Professor Dutenhaver, and that is it pertains to an issue that I'm sure comes up an awful lot. That's the inadvertent disclosure of confidential information. In this instance, it's an employment discrimination case where the mediator learns in a private caucus from the plaintiff's attorney that the plaintiff was recently arrested for possession of illegal drugs. And the mediator inadvertently discloses this information to the opposing attorney during a private caucus with that attorney. I mean, you just killed the deal. I mean, what do you do, Professor?
Let me start by saying the first 3 pages that follow this hypothetical are references to the standards that I had mentioned before. Following that, there are references to the Illinois Rules of Professional Conduct, and following that, the reference to the Uniform Mediation Act. So if we go through these now page by page, the first one on page 5 has to do with impartiality. And although the problem that the mediator has created is a breach of confidentiality, what I wanted to start with this one, because when there is a breach of confidentiality and it is the mediator who has breached that obligation, then you must think as a mediator and as the attorneys in the mediation as to what does that do to the mediator's impartiality. And not just the impartiality, but the appearance of impartiality. So if we look at this first standard on page 5, we see the obligation that comes out of the model standards of conduct. Here, this is a guideline, but impartiality is picked up in the other sources of obligations also. And specifically, the mediator should not act with partiality. If we go to page 6, there's the reference to the obligation for confidentiality that the mediator has when there is a meeting with any two people to try and settle their situation. Again, an unenforceable guideline, but enforceable from other sources. Page 7 is a portion of the standards, the model standards of conduct, that talks about the quality of the process. And when we're analyzing what is going on in a mediation and what are the obligations of the mediator in the conduct of the mediation, so much of what the mediator does or does not do will affect the quality of the process. And so this is written to help us focus on the need to keep in mind that there has to be a process that is going to meet certain standards, that is going to be able to be helpful.
You're going to let me interrupt you anywhere I want, right?
Absolutely.
So in the real world, if what we describe as this hypothetical in fact occurred, the mediator, to my mind, A, has lost his or her credibility. How are you going to get it back? Secondly, what is the mediator going to do when the disclosure of this fact, you cannot unring that bell, is going to have a downward force or be a serve as a downward force on the value of the case, because the property casualty defense people that I deal with all the time, or the commercial defense people in a commercial case, are going to use this as a fact that undermines the resolution, because you've now let a big cat out of the bag that they would otherwise not know about, and it's your fault, and shouldn't you just shut this mediation down?
The first thing
Okay.
Is an act such as that subject to malpractice?
Okay, include in your response, if you would, the question from the floor about whether an act such as that, and I suppose that being that the lawyer told the mediator, subject to a legal malpractice claim. So, Professor?
Well, let's start with the rules that do give us the obligation of confidentiality. If there's going to be a malpractice case against a mediator, it's as difficult to bring as a malpractice case against a lawyer. It's the case within the case and showing the connection to the actual harm. But it would be the basis of a malpractice case if there is the harm to be shown. So I think in good practice, the first thing you do is go back and tell the other attorney what it is that you have just done and talk about what that attorney wants to do about it. This is the kind of thing that I would suggest be done with the attorney only, not with the attorney and his client. And then let the attorney have time to talk with his client, and then come back to the mediator and figure out what can be done with it. And then after that conversation, go back to the one where you've told it. Is that
Judge Nudelman's chomping at the bit.
There is, in real estate, there's 3 words: location, location, location. In mediation, there's 3 words: disclose, disclose, disclose. If something occurs during a mediation that your gut tells you isn't correct, the first thing you have to do is ask yourself as a mediator, what have I done? It's the OMG moment. And now, what do I have to do? Not to repair it necessarily, because you may not be able to repair it, but at least to let the parties know what has occurred. And it has to be a situation where you certainly do tell the attorney that you've just given this information to the other side inadvertently. You let them discuss it. But I think you also have an obligation to go back to the attorney you told it to and said, I have made a terrible mistake. I have told you something that I had no right to tell you. It was confidential information. I should not have told you that, and I apologize for putting you in this position as well, because you have now put the other attorney in a position, perhaps, that attorney has to think about. So you have to let the parties know you've made the mistake. The question then relates to, I think, that Bob is getting to, well, what do the attorneys do at this point?
Right. But before we get there, but maybe related to that, Professor, in the materials beginning on page 8 through 14, 15, you cite to certain portions of the Illinois Rules of Professional Conduct and as well as the Uniform Mediation Act. What do these have to do with the answers that you're giving to us now?
In pages 8 through 12, those are all cites to the preamble to the Illinois Rules of Professional Conduct. We're not going to go into detail with the preamble. Those are the aspirational goals behind the rules themselves. So there's no need to go through those specifically. Let's go to page 13. This rule is written for lawyers. It's rule point 16A, and it's the confidentiality that we have to keep as attorneys for our clients. One of the things that occurs in the field of mediation when the mediator is a lawyer is that we are lawyers 24/7. And so we have the obligations that lawyers have. And the question always becomes, is there anything that we are not obligated to do because we are in a neutral role rather than in an advocacy role? And the general understanding that we have about that is that we are always obligated with regard to the rules for lawyers. That doesn't mean that all mediators are lawyers. There are many mediators who are not lawyers. But for those of us who are, that is required. And if we look at...
Can I interrupt? You said that you're in a neutral position. Are you always in that neutral position? Isn't there a time when you're being asked to evaluate matters and at a level that gets past being a neutral?
The debate that goes on in that is some think very strongly that's a loss of neutrality. And there are others who think that by giving an evaluation of a case, the mediator who is qualified to give the evaluation is helping parties look at the case in a different way in order for them to be able to settle it. And that if you are strategizing a case as one of the lawyers and you are at a good faith disagreement about how the law will be applied if the case goes to court, you hear the opinion of the mediator who is talking from a neutral point of view, both of the attorneys can get an opinion that they haven't really considered before. It can be very helpful for unlocking a case that is almost at impasse over that reason. Now, can it be done in a way that you do lose neutrality? Of course, but it's not necessarily so.
Judge?
Well, we have a hypothetical that we're going to address that addresses that specific aspect of a mediator probably trying too hard or a neutral trying too hard to get a settlement done. But there are two basic styles to most mediations. There's the facilitative style and the evaluative style. Some people say facilitative mediators, neutrals, like to get everybody to sing Kumbaya. Others say that the evaluative pressures too hard and just gives the iron line. This is what the case is worth. Settle it for that or I'm done for the day. There's all kinds of areas in between that. And generally a mediator takes both approaches. You have to take both approaches. At some point a mediator, if he's not or she's not called to give an evaluation, will give an evaluation. Now you may give more than one. You may give various possibilities on how this case may in fact progress and end if it goes to trial. But you're giving your evaluation so the parties can make decisions. One of the reasons why they hire mediators is because of their experience, whatever that experience might be. You're going to choose a mediator that you know can help you get to resolution, and part of the reason is because they've got the experience, either in the court, out of the court, have done a lot of these mediations, and that'll be the purpose you probably hire your mediator for.
Professor, in this,
We have a number.
I know we do. Professor, in the current example, where does the Uniform Mediation Act fit in?
On page 14,
Yes, ma'am.
the privilege, the privilege is on page 49. Oh, Christopher, page 49. Page 14 is the waiver of the privilege.
The waiver of the privilege, and
And
then
then
also the
16
exceptions to privilege.
Exceptions to the privilege.
Correct.
But the confidentiality that is
Is-
provided for, clearly this has been a violation of it.
Right. Now, we have a question from the web.
We have loads of questions from the web. Barbara's asking, was it malpractice for the attorney to disclose the information to the mediator?
I think we said it might be.
And will the Section 4 of the Uniform Mediation Act that you just had up there mitigate damages for the mistaken breach of confidentiality?
Professor,
That's
Read
from
that again.
read the
Philip.
question again.
Philip is asking, will Section 4
Get into the mic.
of the Uniform Mediation Act mitigate damages for the mistaken breach of confidentiality?
I don't know if it would mitigate damages. I think, again, if it could be shown that there was simply a mistake, that this was not the mediator trying to take charge of the mediation and give information that she thought would help, and did it purposefully, I think that basically is the whole issue that we're involved in, what occurred and what would be the damage from it. I think Bob is absolutely correct. Think about this. It wasn't a drug, let's say it wasn't a drug conviction that you can find by researching court documents if you chose to. Let's say it inadvertently the mediator said, you know, the plaintiff, by the way, is 6 months behind on their mortgage payments. So now the defense knows that this person's desperate for cash. And now all of a sudden the offers start to drop way down, or they don't go up quite as high as they are. And this is what can destroy a process. Does it lead to malpractice? My opinion is probably not, but it certainly is a problem.
We got time for another question from the web?
I think if we move on to the next hypothetical,
Okay.
and I'll see if we can catch up with some of these questions
All
later.
right, terrific. So our next hypothetical pertains to a sexual harassment case where the plaintiff's attorney is an inexperienced solo attorney. The plaintiff's initial offer in mediation, that's the demand, is $150,000. The mediator takes this to the attorney for the defense, who says this case will settle for less than $10,000. Tell them our offer is $1,500. You feel that the plaintiff has a triable case, but it appears she does not want to litigate. I take it you being the mediator. The plaintiff in subsequent negotiations drops tens of thousands of dollars with little upward movement by the defense, and the case ultimately settles for $9,500. And add to this fact pattern from the practitioner's perspective that we're seeing more and more lawyers keeping cases where you could argue that they may not have the requisite experience to be handling them, and the clients therefore arguably are suffering. What's the mediator's role in all these circumstances? That it sounds like here you had a defense lawyer who was far more experienced than the plaintiff's lawyer. They go from $150,000 to $9,500. Something's wrong with the picture. What's the mediator's job in that place?
It's difficult. The mediator has to remain impartial during the course of the entire mediation. As a retired judge, I certainly know better than anyone else. There's no question about that. But when I take off my judicial robes and put on my mediator hat, it's a different situation. I certainly cannot give any orders to anyone. This is the aspect when evaluative mediation may come in. I may go into the plaintiff's room at some point and give them impressions of what I've seen in a courtroom, what may occur in a courtroom. I certainly will probably give more than one impression. I might give the best day and the worst day and the day in between if I think it's going to help me get somewhere. At the end of the day, though, I don't know the reason why this person is settling the case for $9,500. She, the litigant, may choose not to go to trial. She does not want to go to a courtroom, and I don't know why. And really, it's not my business, and I'll probably never be told that answer. If, on the other hand, it's because there's a lawyer who is incompetent, well, then the question I have to ask myself is, what do I do in that situation? I can look at page 17, Model Standards for Conduct, about self-determination. Every party has the right to make their own determinations about what they wish to accomplish from the mediation. I have no right to impose my values on it. But the question I start to ask myself is, what if I detect or believe I've got an attorney there who at the very least is not as experienced as the other attorney, and at the very worst has a difficulty, a problem? He may be incompetent. There may be situations where I could tell he is simply not prepared for this mediation, has no idea what the value of this case is. In fact, he doesn't do this type of work. He does traffic court cases, and this is the first tort case he's ever done. I may detect even worse problems than that. I have been in mediations where after lunch, and we took a lunch break, which I try not to do, a lawyer has come back, and I believe the lawyer is not the same as he was when he walked in the morning. And it's a problem for me, and I don't know exactly what to do. I'm not about to call lawyers' assistance program at that point, but I have to decide what to do as a mediator. In very few occasions, and I've done it only twice in all the years I've been doing mediations, and I've been doing them since 1990, I have said I really don't know that I can work this mediation anymore. Mediators out there will get angry at me saying this, but I'm going to return your fees, and we're going to stop the mediation now, and perhaps you should have someone else work with you. I've also, in private meetings with the attorneys outside the presence of their counsel, have asked them that perhaps they should be speaking to somebody else about this case and helping them. Lawyers have gotten angry at me for saying that. I don't say it in front of clients. But to let them know they're perhaps out of their league on this one, and they really need some help and some guidance. If you look at some of the other pages, if you turn to page 18 as well, which continues in impartiality, specifically I'm talking about section C. If at any time a mediator is unable to conduct a mediation in an impartial manner, the mediator shall withdraw. By the way, one of these pages that we're going to be referring to continually during the course of this afternoon is page 19, the quality of the process. Quality of the process is really a mediator's catch-all. That's kind of our safety net. If there is a problem we see going on, we refer to that to let us know whether or not this particular mediation should continue in the same manner, or perhaps should be stopped for whatever reason, continue for another day.
Judge, we have a question from the web?
Yes, we do. And obviously, if anybody in the audience wants to, they can obviously ask it. As to what you were talking about, Judge, compensation of mediators, Thomas is asking as to the motivation also of a mediator, how are they compensated, by time or if there's a successful settlement?
No. In the beginning of mediations, when I give my opening statements, I sometimes, in fact, I always tell the people that I am not being paid on a commission basis. And that while I start to push you and pressure you to let's see if we can get to a resolution, it's not because I get a certain percentage of what the case settles for. I am paid by the hour, as all mediators, as far as I know, are paid by the hour. And that's truly how it works.
But Judge, that goes to something that we talked about in our preparation session and up at the top. That is that as a lawyer who attends mediations on a regular basis, I sometimes get the impression that the mediator, they're out to settle this case. Justice be damned in terms of the quality of the result or what is, right between the parties. The mediator is a failure if the case does not settle. And doesn't, where am I wrong about that? Or, is that, okay, you're a good mediator, so you don't do that, but somebody else is a bad mediator and they really do? I mean, some mediators can get heavy-handed. And so when you talk about the quality of the process, I mean, is it my job as a lawyer when I detect that happening, that I should whip out this standard 6 and say quality of the process and read it to the mediator and say, let's get with the program?
I think if you have a problem with the mediator, that's something that should be addressed privately with the mediator. I know for me, my success rate in mediations is 95%. Why? Because they never end. So if you just don't end the mediation process, it'll be successful. Mediators, like anyone else, try to sometimes gauge themselves by how successful they are or not. In reality, a good mediator knows when to step aside. Sometimes people say mediations are like wine. They settle when they're ready to settle and not before. And a good mediator is the kind of mediator at the end of the day, in a difficult case, the lawyers come to the mediator and says, we really didn't need you today, but it was nice being with you. And you've probably done a pretty good job.
What did the grapes say to the little boy that stepped on it? A little wine. That's bad, I know.
Stick to your
There's a question in the audience, Anna?
Yes. The question that's raised in hypothetical 2 on page 16 to me really seems like a question of power imbalance and the role of the mediator, the ethical responsibility really to try to do what we can as neutrals to balance the power. Certainly sexual harassment cases are cases that a power imbalance is often present. And so then you put on top of that an inexperienced plaintiff's attorney. And it seems like that's one of those times where if you're not able to kind of level the playing field to some degree, not that it has to be equal, but I certainly think it raises an ethical consideration about, can you go forward feeling that both parties can participate in good faith? I, too, have terminated mediations, for example, when domestic violence has become an issue, and I did not feel that I could competently mediate the case, but it seems like that could bring a similar situation under hypothetical 2.
Katheryn and I may be approaching this a bit differently. I think Katheryn should talk about this as well. Because of my background, I approach mediations from a judicial perspective in many ways. When I sat in criminal court, if I saw that one party was being disadvantaged and that was the defendant, I felt it was my obligation to protect the constitutional rights of this defendant and make sure that I imposed myself somewhat in some aspects of the trial. When I tried civil cases as a judge, that wasn't my job. If there was truly 2 lawyers and one was just much better than the other, I had to sit back there and watch it and watch a bloodbath occasionally. But that was my role. As a mediator, you're right. I think while there is nothing I can point to except, again, the quality of the process, I think the best, though, I can do at some point is to end the mediation or give advice to the counsel, as opposed to start to be an advocate for him or her in the other one's room. Katheryn, I'm not sure if...
A question from the floor.
Real quickly, Judge, would your answer change in that personal injury case if the plaintiff was a minor?
Again, the plaintiff's being represented by an attorney, and very often I'll have a guardian ad litem in there with the minor as well. I've got 2 heads now thinking about this, and I'm not about to substitute my judgment for theirs. I simply can't. I don't believe I can do it.
Professor?
I think the most difficult case for the mediator is where one side has competent counsel, the other side does not. And it doesn't have to go to a very high standard of competency to find that there can be real harm to the client when the lawyer is not making good representation. And I think that when the mediator meets with that lawyer and does so individually, not with the client, of course, that a lot can be said. And I've had the experience of telling lawyers that the last time I looked at that law, I had a different understanding. And before we meet again, would you look at it again? Because it's been a while, but I really do think that there could be a different interpretation.
Do you think it's...
I think we have to be very active in terms of helping where there is a situation where the lawyer is not doing the lawyer's job.
Do you think it's a fair thing to do in mediation, given that what you just said, that I would say to you, look, mediator, you are anchored in a view of the law that I think is incorrect, and it's impacting your ability to bring us together. Would you mind accepting from me a bench memo, for lack of a better term, or a brief on this issue, and ask the parties to submit to you briefs? Do you do that as a mediator? If the answer to that question is yes, then doesn't that then switch your role then from a mediator to being more of an arbitrator?
Depends on what you do with it when you get it. And that has to be part of the understanding before they prepare the memorandum. You cannot step out of the role of trying to bring parties to an agreement and suddenly be giving a binding decision without their agreement. But many times in a mediation, as it's going along, and usually it's the last issue or the last 2 issues when all the rest have been taken care of, they will say to you, will you now make a binding decision? Will you now be the arbitrator? And if that's what they want, and if you, the mediator, feel that you can do that impartially, and you're not going to be relying on things you learned in individual meetings with them, where that does not level the playing field.
Judge, are you shaking your head no?
Well, I don't.
Wait a second.
Yeah.
And then I think you can step into that role, but don't do it without a written agreement that you're going to be the arbitrator. And that's for the purpose to be sure they understand that you're switching into that other role.
A question in the back of the room?
Yes. We keep focusing on competence in the sense of one lawyer having more ability than another, but that's not the balance of power question. And from my perspective, that's why mediators have to level the playing field. We're talking about a sexual harassment case in which you have a lawyer, you have a company on one side, presumably, that has a great deal of resources. You have a lawyer on the other side who is not only inexperienced, but probably has the lack of financial resources to try a difficult case, to hire the expert witnesses, to prove damages, which in sexual harassment cases are very, very difficult. And so the mountain is much higher to climb. And so it's not just about competency. So what's the mediator's role in trying to level the playing field in that environment?
Again, if you look at page 22 and 23, which are just the definitions of competence and diligence of an attorney, if you are, as the mediator, are detecting that the plaintiff in this case is not being adequately represented in this mediation, then I would agree the proactive role you can take, because I've been in those situations, is to call the attorney outside of the room from his client and explain to the attorney the difficulty you're having. And not necessarily start to talk about, hey, this case is worth $90,000. Why are you down to $25,000 at this point? I'm not going to go that far. What I am going to do is say, I think there's problems here in what you're viewing the case as and what perhaps the case is or isn't worth. I think you have a problem in, and again, I've used the aspect, I've read the law on this. You and I just simply disagree on the applicability of the law. And I'll do whatever you want. If you want, I'll try to get a continuance and let you stop this for a bit, and perhaps you can come back later. But I honestly still don't know why this woman wants to settle the case. You know, the case could not be a case. It's a possibility there is no case. Plaintiffs, Bob may disagree with me, aren't always correct. This might not be a real sexual harassment case for all I know, and this $9,500 is truly what it is. It's a nuisance, and they're offering nuisance money, and that's all the case perhaps is worth. Now, if I believe it isn't a nuisance case, it's a real case, I've got to keep in that line of my neutrality. I don't do what Katheryn does. I've never done it, and I don't know that I ever will. If I think there's an opinion, a legal opinion, that's going to break a logjam, I'll recommend that another person, another retired judge I know, another professor I know, they can hire some person, let that person make the decision, and then let's work on, once the decision is made, if they're both agreeing to be bound by it for the purpose of the mediation only. What I will do in a mediation is in private caucus, after we've met as a joint and private caucus, I might tell them what I think their percentage is of winning the summary judgment motion, that it probably isn't very high. And if that's what they're banking on in this case, then maybe they ought to keep reevaluating what the value of the case actually is.
Question from the web?
Yes, we have lots of them. Scott is asking an interesting question. What remedies would a party have if the mediator tells the presiding judge over the matter that if he or she makes or denies a ruling on a dispositive matter, that it would help settle the case?
Ooh, that's a good one.
The question is the mediator talking to the judge on
Correct.
the case?
Right.
That's the question.
And how's that
Absolutely.
supposed to happen?
Don't do that.
Don't do that. Why not?
As the rules have developed, that is, most of them, in other jurisdictions as well as Illinois, will say that the mediators not to talk to the person who's going to make the binding decision. And this comes from the privilege in the Uniform Mediation Act, and it comes from the standards that we have.
We have a question also from Phil, that has the judge ever had to report a lawyer to the ARDC for ethical misconduct?
I've been practicing now for close to 40 years. I was a judge for 21 years. I've been now doing private practice of mediations and arbitrations for 6 years. So in all my career, I have never had to report anyone to the ARDC on a HIMLA violation. I've been very, very fortunate. Or perhaps I've set the bar too low. I'm not sure which one it is.
Well, you know,
I haven't had to do it.
No, Judge, on a related note, because we talked about Himmel early on, and, you know, at the end of the day, and maybe I've been around too long, you've been around too long, but, you know, sometimes I see some of the young people in the crowd, and everything is strictly construed, and every line is drawn in the sand, and everything is black and white, and, Yet is that where we as a profession and with civility and being the norm and trying to do justice for our respective clients? I mean, what's your advice to us about that? Do we want to pick a nuclear war on every single subject?
We don't. We're going to get to Himmel and a possibility of a Himmel violation during the course of a mediation. I think that we as mediators owe a duty to the process, and if the process is unethical or appears to be unethical or verges on being unethical because of the conduct of an attorney, then I think at some point, again, in my opening statements, by the way, I always tell everyone that I may call your attorney out of the room to talk to your attorney about nothing to do with the case necessarily, but the process, the procedure. And I do that so people don't think I'm hiding anything from them. And that's when I have the conversations with the lawyers, and that's when I tell them my concerns. I have not had to do it very often. I will tell you that I think the ethical standards, at least the lawyers in Illinois that I've dealt with, is extraordinarily high. People have said to me, well, isn't it true cases don't settle because lawyers have to keep billing? How do they pay for their summer homes unless they try the case? I have not seen that. I truly have not seen that. Are there instances when I think it could settle at this point and I don't know the reason why it isn't settling? Of course. But do I think that lawyers don't settle cases because of their own self-interest and not the client's interest? I really have seen that so infrequently as to almost be able to say I've never seen it.
Let's turn to hypothetical 3, and I represent to you, Judge and Professor, that when I read this in our draft materials, I giggled because I had some lawyers report this very incident to me recently that happened to them. And that is, in a dispute, in our hypothetical here, it's a contract dispute, that the mediator, who has extensive legal knowledge of a particular commercial issue, tells both sides that he knows what the value of the case should be. The mediator then demands to speak to the client and the adjuster in the case. The mediator makes it known in no uncertain terms that he wants this case to settle. Okay, what do the lawyers do in that circumstance? What do they do? What do we do, Professor?
My first reaction as the lawyer is that you are not going to meet with my client by yourself. You cannot demand that, and if you do, the mediation is over. That will get the attention of the mediator. But it also happens in ways that are not that open, where the mediator doesn't know what's going on. So let's assume the mediator calls the client after one mediation conference and before the next one takes place.
Wait a minute. What right does a mediator have to call my client?
Absolutely
None.
Well, why did he or she do it? Wouldn't then, going back to what I said earlier about this, why wouldn't I then want to just call the mediator up and send them I should be keeping copies of this, the quality of the process in my briefcase, bring it to every mediation and pass it to the mediator. Shouldn't we be doing that as lawyers?
I think we should also look at the Illinois Rule 4.2.
Illinois Rule 4.2 tells us what?
And that's on page 29.
Okay.
Lawyer shall not communicate with a person that he knows to be represented unless consent has been given. And I think that when we talk about mediators who are lawyers being obligated under the rules, that we also have the obligation not to talk without permission of the lawyer.
I thought that the rules of professional conduct only applied to me and my opponent, that it had nothing to do with you guys, that you're above it all because you're trying to do justice and get the case over. So you're telling us that the only rules of professional conduct apply to you as mediators?
Yes.
So can I report you for a Himmel violation?
Yes.
Fascinating. You ever had it?
Pardon?
Ever had it? Have you ever had that?
Yes.
Ooh, I didn't expect
Where
that,
I
yes.
was the attorney,
Yeah.
and a mediator did talk with my client without telling me, without asking me, and it was in between the mediation sessions.
Can you tell us more or no? I mean, we're here to learn.
The way I handled it was that I called the other attorney, and we agreed to continue negotiations without the mediator.
Great. Okay.
We have questions
Judge,
on
go
the
ahead,
web.
and then we'll have a question from the web.
One of the things you might be noticing that Katheryn and I are doing, and I think all mediators do, lawyer mediators, is we've taken the rules that guide us as attorneys and have somewhat translated them or morphed them into additional rules in effect for us as mediators. So while we would never dream as an attorney of calling another lawyer's client in a dispute, we as mediators would never dream of going beyond the lawyer and calling a client. I've been in so many mediations, and I'm sure Bob has as well, where the adjuster isn't there. You've got the lawyer there. My evaluative work of telling the lawyer for the defense what a horrible case he may have and how he's going to lose his summary judgment, lose the 2-6-15, and at the end of the day pay a lot of money. Well, when I'm done with my wonderful presentation, he then calls the adjuster and gives up a half value of what I've said to him. It doesn't do any good. I have asked lawyers, may I talk to your adjuster personally? Can you get him on the phone? Can we have a conversation? Very often it's been, sure, no problem. Very often it's been, no, Judge, I think I'd like to talk to the adjuster myself. I have the adjuster's name. I have the adjuster's phone number. I'm not going to call the adjuster. Why? Because I remember what 4.2 says, that I can't talk to somebody else's client. Appreciate I'm not the lawyer, but I think it applies to me as a mediator as well.
That's a question from the web.
From the web, Joe is asking, how does a mediator avoid taking advantage of the more reasonable party who they know they can move and thus allow the unreasonable party to benefit from their unreasonableness?
There you go.
And then a question for Mr. Clifford.
No, I think it's a great question because it says, how does the mediator avoid the more experienced or capable or knowledgeable on that particular case lawyer from taking advantage of the less empowered lawyer? Is the I think
that's the question. Yes,
that's the question.
Mm-hmm.
And I think you told us it's not your job, man.
I think one of the things, no, I'm not going to say that. But I think one of the things, think about being in front of a judge. Think about if you're in front of a judge and there's one lawyer doing a great job arguing the motion, the other lawyer's not doing a very good job. Does the judge jump in there and help the lawyer who's not doing a very good job? The answer certainly is no. The judge makes his ruling. In mediation, I appreciate that it's not the same thing. But again, these people have hired their lawyers for whatever reason. They're in a mediation, hopefully, if they are to settle the case. And what they're going to do is based upon their own interest. I am not going to get in between a lawyer and her client to tell the client that the lawyer's doing something wrong or is inept or doesn't know what they're doing. What I might do and what I might be able to do in the private caucus is in front of the client, to the client in effect, tell them all the possibilities that may occur if this case doesn't settle. And some of them may be good possibilities. And when I leave the room and the client says to their lawyer, well, you know, the judge just said that there's a possibility that, you know, this case may go a different way and maybe we'll do much better. What do you think about that? And the lawyer may say, well, he may be right. Or the lawyer may say he's wrong.
Question
There's not
for
a
Mr.
lot
Clifford.
I can do about it.
Sorry, question for Mr. Clifford, but
One-
Professor?
Professor? Go ahead.
One of the things that occurs as a mediation ends is that you walk out of the room as a mediator and you say to yourself, I wonder really why this case settled. Or, I wonder really why it didn't. There's a lot that you don't find out as a mediator, and there's a certain obligation of us letting go and letting happen what is going on between the attorneys and the parties.
Question on the web for me?
Yes, that you seem to have expressed a preference for trial over mediation. And assuming this is coming from a position of an attorney for the plaintiff, is some of it based on the possibility that too much information about your case or client might be revealed at the mediation?
No, that's a great question, and it's something that we struggle with all the time. I struggle with all the time, and that is that one of the axioms of our practice is we say we don't want to try our case in mediation. We don't want to try our case in pretrial. So I think we are always holding something back. Number one, even on, you know, one of the fallacies of most of the plaintiffs' bars that every case they have is a big case. Well, not every case that we have is a big case, and yet I have to tell you, I think it makes a real difference to real people that if I'm negotiating a case and the value is $120,000 in my opinion, I'm going to fight for that, and if I've got to threaten and trial, that's what I really believe. I mean, I believe the data show, and the data are clear, that the higher numbers ultimately on settlement, whether it's a $120,000 case or it's a $12 million case, that the closer you get to trial, and the more it takes that to get people to be realistic. Now, that's just the world that I'm in. So, I like mediation. I like settling cases, but I'm not there to give them away, and I don't view it as my job to give it away. And for my clients, it makes a difference. If I get an extra $10,000 or an extra $1 million for them, I think that's important to them. And and I've had this. I had just recently. We were talking about this earlier. That I had a mediator say to me, "Well, what are they going to do with all this money anyway?" Well, what right did the mediator have to say that to me? And I really wish I had that thing. I would have shown it to him. So okay.
We also have another question from Barry asking: is it your duty to report to the court if a party is not mediating or acting in good faith during the mediation?
Go ahead, Judge.
In the court-appointed or the court-mandated mediation, there is a questionnaire that mediators are given. And basically, what I report is who was there, and I report what occurred. I don't report on who I believe was negotiating in good faith or bad faith. I believe that confidentiality and of the process is sacrosanct. There is only one or two areas where you're going to violate confidentiality. One is Himmel. Other than that, I am not about to report to anybody outside the mediation who I believe negotiated in good faith or bad faith.
Okay. All right, let's move on to hypothetical 4, which deals with a lack of authority. So here we have a scenario of an injury construction accident case of a plaintiff who has a catastrophic injury. Her lawyer makes a $12 million demand. There are 4 defendants in the case. 3 have made relatively small or modest offers, and the 4th tells you, the mediator, that he has been given no authority to settle the case. I think this fits into this question of good faith, where you have someone who shows up to a mediation without any authority, without any intention to go out and get it, and it's going to take 4 to tango, the mediator concludes, and why don't you just shut it down, or what do you do, or do you tell the other lawyers to go back to the court and tell the court that no one's acting in good faith? And so after a first initial answer by Judge Nudelman, we'll have a question in the room on the other side there, Anna. Go ahead, Judge.
Sometimes you find this information out before the mediation even begins. I enjoy reading pre-mediation submissions. I'd like to get an idea what your case is like, and I'd like you to give me as much information as you think I need to help me be a good mediator, which is to have enough information so when I talk in private caucus, I could challenge some assertions made to me that may not be factual. I could also tell them of what very often will happen in a situation like this in a courtroom. That's what I think part of my value is. Often in mediation submissions, in the confidential submission or the confidential portion of the submission, I will get a statement from a defense lawyer saying, and we're going to come there, Judge, and we're going to mediate in good faith, but we're just a nominal player. We have the icing on the cake, or the sweetener in the tea, or whatever other things you can think of that are said. And I've read the mediation statement, I've read others, and I realize they are not the icing on the cake, they're the flour to make the cake. And I now am about to start a mediation in a week or two where I know I'm not going to have enough money to make this case worthwhile for anyone to be present. The real question is, what do I do in that situation? And what I'm always concerned about on page 31 is confidentiality. What do I disclose? What do I disclose before the mediation? What do I disclose in the mediation? In the mediation, it may be too late. By the time we're at the mediation and I go to collect the money from the various rooms to see if I can get a first offer to the demand, and I realize I'm not going anywhere, at some point I'm going to ask the lawyers, perhaps, to all meet with our clients to discuss their positions with each other. I'll have the defense meet as a group. I will then have to have what I sometimes call the old fund and fight. What is this case worth? And now how do we get there? How are you all going to pay for what this case is worth? I'll ask them to occasionally meet with the plaintiff's lawyer, saying we are in a position now where we're really going to end before we begin. I think we ought to talk about this case to see if we can get there somewhere. My problem comes in is when I get this in a pre-mediation submission, do I then get on the phone and call Bob and say, Bob, we're going to do a mediation in 2 weeks. I think you're going to waste your time to be there because Al Miller says he has no money.
And that's one of my questions. I know this gentleman has a question, but do you have the right, though, Judge? Do you feel you have a right as a mediator before the mediation begins on an ex-party basis to call me up about that?
I don't think I have the right to tell you what's been told to me in confidentiality.
Okay. There's a question there, sir?
Yeah. Would you try to take the three defendants who, even though they have small offers, to basically get them up to some type of significant offer and to put that on the table, which would bring the one that never had wanted to basically put any money on the table, that if the plaintiff decides to accept a significant offer from the other three defendants, he's going to trial by himself, and frankly, if given your judgment, he might be picking up the vast majority of 12 million plus. Would you try to work out something like that? Do you ever maneuver where you have multiple parties on the side basically play one off the other in order to get the offer up to the plaintiff's demand?
Oh, now you're asking for the mediator's secrets, deepest secrets.
There's a mediator god, and the god is, either you pronounce it Janus or Janus, the Roman god that speaks out of both sides of his face. I will tell you that I've said things in private caucus in one room, and I've perhaps given a different spin on that same set of facts in the other room. I have spoken to individual defendants and told them what possibilities are when I'm asked, or I volunteered even when I'm not asked. And it's important that the person with the lawyer, the decision maker, hears it from me. I know the lawyers told them, but if they hear it from me, I truly am the neutral. The lawyer very often for their own client is not a prophet. I'm the prophet. I will tell them independently, and they'll help get things going. And by the way, but we're talking about lack of authority, and let me make one suggestion to all of you that do mediations. If you're doing a mediation of a case in a courtroom, and you're about to do it privately, or even if it's court-ordered mediation, ask the judge to make sure that everyone at the mediation, that anyone who's at the mediation be a person with authority. In other words, not just the attorney. I want the adjuster there. I want the CEO there. I want whoever it is there that can make the decision there that day. I can't do it as a mediator. I have the velvet glove. I've lost the iron fist. But the judge that you're in front of can do it, and will make the mediation much more successful if the person with the authority is in the room with me.
And to that score, Judge, do you believe it's a good best practices for lawyers who are, I get a phone call, multi-party case, I get a phone call from one of them saying, hey, let's try to get a mediation going with Professor, and we want to do that. Do you think it's a good practice for us to respond, yes, so long as we get a court order? We go in on a court order, it's on an agreed order, signed by all the parties, saying, I understand that the parties want a mediation, that's fine, but I ordered that everybody have the authority that you just described. Is that a good practice to start?
One of the programs that we have going right now in the Law Division here in Cook County is the mediation program where the judges will refer cases, but it's done by agreed order. It's not done by order without agreement. But in the order, it says that everyone with authority must be there. If someone cannot be there, and if it's okay with the mediator, then that person it's usually someone who's out of town, that person can participate if they participate throughout all of the joint sessions and the individual caucuses by telephone. And getting that into the court order really takes care of a lot of the problem.
So
another
go ahead.
Another thing that we've done is that if there's going to be a board of directors, say, that has to sign off on a settlement, it's very helpful to send the resume of the mediator to the board for their approval before you ever begin, so that they have a sense of thinking about the case and making that initial judgment about who the mediator is.
You know, if you go to this case where the fourth defendant tells the mediator he has no authority, and any fair, reasonable review of the facts indicate that they do, why don't I have a Himmel obligation, because that lawyer violates Rule 3.2 of the Illinois Rules of Professional Conduct, where it requires expediting litigation, that a lawyer shall make reasonable efforts to expedite litigation consistent with the interests of his client. Is that a HIML violation? You had it under this.
Well, you know me, I don't see HIML violations as often as perhaps I should.
Right.
I think that certainly at some point, and again, I have had lawyers that have gone back to the court, and I've had lawyers go back to the court to petition the court for one side to pay the fees for that mediation because they didn't mediate in good faith, because they didn't come there with authority, because any fair interpretation of what their role is, their client's role is in this case, should be. In fact, there has to be authority because they are a player in this case, and judges have absolutely ruled that that party should play. Judges have asked that we testify, and as far as I know, Katheryn and I have always declined that request.
Okay, a question from the web.
Yes, one question is that if there's an incompetent attorney, do you have a duty to stop the mediation? And on the other side, Patricia is asking if it becomes clear during the mediation that the lawyer has not properly prepared his client for the mediation, do you feel as a mediator to try to convince the client to take a certain amount of money?
You know what, can we hold the answer to that till we turn to the next hypothetical, which I think will give the judge and professor an opportunity to answer. So let's move to, either of you have more to say on number 4. Let's move to the pro se litigant.
The only thing I want to say on number 4, if I can just interrupt, is we've been thinking about what do you do with the incompetent attorney, the attorney that's not doing their job, and a suggestion is, why don't we continue this? Why don't we pick it up another day? Why don't we take a break and go talk to somebody else that you think knows about this? Well, that's well and good. But now what do I do when I walk into the other room? They've come there. They've paid their fees. Their client is there. They're prepared for the mediation. They've done all their homework. They are competent at what they do. Well, I think they're going to think that it's unfair. They may think, as a matter of fact, that I've lost my impartiality because I seem to be now wanting to protect the other side and giving them another bite at the apple, another shot at this mediation. And that may be a problem. And again, it depends how we approach this and what we tell the other side. And again, what do we tell them? How much can we tell them without violating confidentiality? A day in mediation is a hard day sometimes.
Okay. You know, can I interrupt this because we keep talking about confidentiality? You know, what's your view about that subject overall in the process? I mean, why can't I go out and blab about everything that I'm hearing, and why can't you? I mean, what rules are guiding you in your view?
The Uniform Mediation Act and also the standards, the concept.
You know, most mediations, by the way, don't have a written agreement.
Pardon?
You know, most mediations don't have a written agreement per se. That when you deal with many of the commercial matters, there's an agreement.
Right.
But oftentimes, when we get a phone call saying we agree to mediation with Judge Nudelman or Professor Dutenhaver, we say yes, and we all show up for mediation, and we don't sign anything. But is this one of those deals where if we don't have a contract, the law wrote one for us? If you don't have a will, the law writes one for you?
There is the law of confidentiality in the Uniform Mediation Act, but advice to attorneys, I would never go to a mediation without an agreement to mediate that also contains a provision for confidentiality.
Even in that car crash case or the slip and fall?
Yes.
Mm-hmm. And as a mediator, I wouldn't conduct one without.
Every mediation I do has a confidentiality clause.
Yeah, but that's because you work for this big company, ADR Systems, and they have
When I worked on my own, all my mediations there was a form that people signed saying that our mediation was confidential and would not be disclosed to any parties, any outside parties. And again, we had exceptions to it. The confidentiality clause was really for me. It was for me that they can't force me to speak, that I would not go to the court, that I would not tell them who's negotiating good faith, that I would not tell the court what I thought the case was worth. So the confidentiality agreement was really to protect them from me more than to protect them from each other.
Well, Howard asked, what about the participants and the attorneys? What are the limits of confidentiality with them?
So in other words, can I go after we have a failed mediation, I can go running into Judge Hogan, who's set the case for trial on Monday, and I say, we had a big mediation last week in front of Judge Nudelman, and that crazy defense lawyer Dutenhaver, she was unreasonable, she didn't come with authority, she didn't bring any money, She didn't accurately state the law, no wonder it failed. Let's pick a jury. Go ahead.
Well, when I used to teach judge school, one of my first lessons is LaSalle Street is really a pretty small street. Within 30 days, you've made your reputation as a judge. I think it takes a little bit longer for an attorney to make his or her reputation, but I think it's an awful risky thing to do for a case or two to do that. In the opening statements, we tell the litigants what we're doing here is private. It's a private mediation. The parties will not go in front of the judge and say, Judge, at the mediation they offered this much, or Judge, they came down to this. We inform them that will not happen. The lawyers will certainly not do that. If you have a lawyer that does it, maybe it is a Himmel violation. I'm not sure.
But we could agree, though, that we will let the judge know what happened, certainly, right? Okay.
Private contract, you can make whatever agreement you wish.
Okay, fair enough. Let's move on to hypothetical 5. This is a landlord-tenant case where the litigant is a pro se, but facing eviction. The landlord, a corporation, represented by that big GC back there, Mr. Conley. Hi, Peter. The landlord makes a final offer. The plaintiff may stay for 2 more months if the plaintiff pays past rent, future rent is escrowed, and agrees to a judgment for eviction at the end of 2 months. The plaintiff asks you, the mediator, if the other side is correct about the law, and the plaintiff also asks, again, mindful, a pro se litigant, what do you recommend, Your Honor?
One of the...
Okay. Professor, what do you say?
I say call Mary Pat Bent.
Okay, well, we're going to
right
talk to
here.
Mary Pat in a moment.
Pardon?
We're going to talk to her in a moment.
And she has had experience with many pro se cases. And so I'd like to start with her.
Okay. In the audience, ladies and gentlemen, we do actually have one of the foremost experts. No, seriously, on this subject.
Oh, I thought it was a joke. I'm sorry.
It wasn't a joke. It wasn't a joke, but on the ethics of mediation and ethics of ADR, Mary Pat Benz, who's been kind enough to join us today. So, Mary Pat, let's pose that question to you that's on the board.
Well, you're too kind, but let me give it a shot because I have done a number of pro se mediations, in particular landlord-tenant cases, and this is a scenario that really does come up all the time. This is one situation where the likelihood is you will not have a mediation agreement or an agreement to mediate. It's one situation where the likelihood is that you will not have a pre-mediation conference, so you can't talk to these folks in advance. What happens in my experience is we go out in a hallway, judge says, all right, go talk to the mediator, everybody goes out, we learn for the first time everything that's involved in this dispute. And it often happens that both sides are pro se. It may happen that one side is represented and the other is not. The issues with pro ses are, number one, is dictated by the rules of professional conduct, specifically 2.4, where as a lawyer mediator, I must tell the pro se, I am a lawyer, but I'm not here acting as a lawyer. I'm not your lawyer. I'm not their lawyer. And I'm not to give you legal advice. I cannot give you legal advice. I'm here to talk with you to see whether or not there can be a dispute resolved. And also, I can't order you to do anything. I'm just here to talk with you and to make sure you talk with one another. Easy to say, you can write that out and just read it to them. Harder to execute because they are pro se and they really don't often enough understand the system. And so when they do talk back and forth and you do it in joint session and in private caucus, it very often will happen that one of the pro ses will say, all right, so what is the law here? And they will also say, well, what would you do if you were me? Or they would say, what does that mean? And what, is this evidence going to come in, all this stuff they're talking about? So I think if you're doing pro se mediation with pro se litigants, you sort of have rules of thumb in your mind, and you say, there's a line that I've drawn, personally, a line that I've drawn between common sense and legal advice. Often they're quite the same.
And what you just described, though, to us, though, is included in our materials at page 40, which is Rule 2.4B of the Illinois Rules of Professional Conduct. when the lawyer is serving as a third-party neutral, is that right?
Correct.
But you also cite, or we cite in our materials on 39, Rule 1.14b, with a client with diminished capacity. And if memory serves me correctly, that has been interpreted diminished capacity simply to also include just lack of knowledge of the law, ignorance of the law. It doesn't have to be some mental incapacity. So doesn't the lawyer for that big corporation that's trying to oust this person at some juncture have a duty professionally to lift the heavy hand off of what they're trying to do to take unfair advantage, going back to that balance of power thing that we've been talking about earlier today?
Yeah, I think there is quite a bit of merit to what you say, but focusing on the pro se certainly does have less understanding of the process than someone who's represented. And so it may require more time, I think probably just as a judge would say when I have a pro se litigant in front of me, I take more time to explain to that pro se litigant what's really happening here and what are the consequences of a ruling or a position. Taking more time with the pro se litigant is pretty much required. Okay. What can you do with that time, though, is I guess the question I was answering, and you really can't advise them as to the law, I think, but there is an area of common sense that is also the law, believe it or not, and you can tell them, Judge Nudelman is a very fair judge, and I don't know what he's going to do, but I don't think he's going to let you stay in that apartment for 6 months without paying any rent. What do you think about that? It brings them into the reality of the situation. It really does make them think about the law, even though you're not advising them as to the law. And you do the same thing for the other side, a landlord representative or not. You say, do you really think Judge Nudelman, you've seen him up there, you really think he's going to give you possession of this apartment now and throw that family with the 5 kids out on the street? And by the way, it'd cost you something. Even if he did that for you, it would cost you something. These are right in that area between advising people as to the law and telling them pretty much on a common sense basis what they can expect.
Okay. Some questions from the web?
Yes, about the process of mediation itself. Do you encourage or discourage opening statements, and what benefits or detriments do they bring? What about exchanging mediation briefs? Does it help or hinder the process? And also, if an attorney comes with no backing documents, no documents to back them up, and just their word, do you stop the mediation or do you allow it to continue?
Okay, so there's 3 different areas, I suppose. Opening statements,
Exchanging
mediation
binders.
materials, and
Exchanging briefs.
Exchanging briefs, and a lawyer coming, telling you, trust me on this one, Your Honor, these are the facts. So so we'll start with Professor Dutenhaver on this one.
Starting the mediation is the first phone call that you have with the attorneys. It isn't at the time of the mediation conference. Setting it up so that we can optimize the time in person together means that submitting the materials ahead of time, the submission that describes the case from a legal analysis of the legal issues, and also submits the documents that are needed for the mediator to understand that, I think are crucial. And if you get that ahead of time, then you are ready to get right into the case. That usually is followed by other phone calls still to get ready for the case. At the opening statements, there's a debate in the field where some think the opening statements, where the attorneys are repeating what's in the submissions that have already been given to the mediator, does nothing but exacerbate the feelings. And that if that happens, they're afraid that it will make it harder to settle. A very legitimate concern.
Hey, let me interrupt you here, because how do you feel when it happens, and I've seen this happen a lot, where in these opening statements, the other side wants to say it's sorry. So, you're using this confidentiality stuff of yours, that, you walk in the opening statements, the lawyer says, because the parties are there, Mrs. Smith, I really want you to know that we're really sorry for what went on here. Now, I bring this up in the background of the program that's out there called Sorry Works. There's a program out there called Sorry Works that if we apologize, the likelihood of you suing us is lower, the value of the case is lower, yada, yada, yada. So could you speak to that when you're both smiling here? Will you speak to that in your remarks?
This is not a loaded question, though.
No, it's not a loaded.
No. I think
We're here to learn, Judge.
not all people who want to say I'm sorry should be allowed by their attorneys to say I'm sorry. The preparation for the case, and the mediator can help with this, is that if there is at some point some acknowledgement that you think is going to help from your client, often the lawyers will talk that over with you ahead of time. And if you think that's going to help, let's pause and talk about it before that occurs, and talk about the best way for that to occur. I think this fad that's going on, that I'm sorry is going to solve everything in a mediation, is not well-founded, and it can cause great harm.
Let me just add to that, and I agree totally and completely, but let's talk about some cases that are not the $12 million cases, or even the $120,000 cases. They're smaller cases, but the plaintiff believes it's the $12 million case, or their $120,000 case. Sometimes a plaintiff wants to hear someone acknowledge, not that they're at fault, but they're sorry for the predicament the person finds them in. Now they have a neck, it still hurts. It always hurts. When she wakes up in the morning, it hurts her. And it all happened after she fell in Dominic's on the banana peel. And there's no question that saying we're sorry you fell in our store is something that I don't think is a bad thing to say.
Why isn't that worth 120? Never mind, I'm sorry. Go ahead.
I don't think it's a bad thing to say. I think that, in fact, these things are good things to say. Let me bring one more thing to you. In a mediation, this is the only time that the person with authority, the insurance adjuster, is going to get to meet your client if you're a plaintiff's lawyer. And while a lot of plaintiff's lawyers think it's very, very dangerous to have their client make an opening statement, let's think about this ethically just for a moment, or if not ethically, practically speaking. If your client makes a statement, not whose fault it is, but what her life is like now, what has occurred since this accident happens, how she gets out of bed in the morning, in effect, if she's capable of doing it, her own day in the life. And this adjuster hears that. I have seen adjusters at mediations scratch out things, write things, and I have seen what I think is a different offer than would have happened, because now this adjuster sees what this might be like on the witness stand. I think opening statements are extremely important. I agree. They shouldn't be confrontational if you can help it. But they should be informational about why and how you intend to go somewhere. I can't force you to do it, certainly, nor would I dream of doing it, but I think it should really be seriously considered. You've been talking lawyer to lawyer. Have you ever talked to an adjuster before? The answer is no, and you probably never will again. So it's a good thing to talk, and the same thing for the defense. The plaintiff's lawyer certainly told his client what the case is about and what the value may be, but now he hears another point of view. And the other point of view now make that client maybe start to think in a different light. You still have control of your client, hopefully, but maybe it might be a little bit easier for you now to get to a point that you want to get to. So I think they're important. The pre-submission briefs are incredibly important. If you're not going to tell me what the case is about, you really don't need me for what I charge an hour. All you need is someone to walk in back and forth, 1 million, 50,000, 950, 75,000. I mean, you don't need me for that. So if you give me information, I can help you with it as well.
Okay, great.
I have two more things on that.
Yes, please, Professor.
The chance for a lawyer to be able to present their case to the opposing client is a golden opportunity, so that the opposing client does not just hear about the case from their own lawyer. If you have the opening statements, you get to do that. And at the end, I think when you're deciding whether to settle or whether to pursue litigation, if you have set the stage at the beginning so that the comparison of what is likely to happen in court to what are the terms of settlement at the end, it makes for a more informed settlement.
But we have an interesting question from James that says, does a lawyer owe a mediator the same duty of candor that he would a judge? Is it ever ethical for a lawyer to tell a mediator a bluff in order to pressure the other side?
Good one. Judge, you smiled.
I bluff all the time.
Well, you know, it's the old...
Katheryn said, for those of you who didn't hear, Katheryn said she bluffs all the time, or hears bluffs all the time, one or the other. They bluff all the time.
One of the reasons why most mediators don't ask initially, or perhaps ever, what is your bottom line? What's your floor? What's your ceiling? It's kind of a ridiculous question because it very often changes during the course of the mediation. And why force someone to lie to you? They're going to lie to you anyway, but why force the lie out of them? So what lawyers always do on both sides is, judge, this case is not going to settle for under $1 million. There's just no way that it can't settle. And of course, you sign a settlement agreement for $600,000.
But I don't know that you answered the question. But the question is it ethical for me to do that?
Well, ethical is you're telling what you're trying to get your client, what you think the case is worth, and that's what your belief is.
So it's okay for me to lie to you?
You're not lying to me if you are telling me the case is a $12 million case, but you decide to take $6 million for it. You've decided during the course of mediation that when this case goes to trial, $6 million settlement is not a bad settlement for this case.
There you go. Katheryn?
There's also a difference between mediation and arbitration in that regard. The rules that require us as lawyers to be candid to the tribunal is saved for the arbitration process. That is not the mediator. The mediator is not going to be making a binding decision. So bluffing takes place in mediation.
But wouldn't you agree, though, that it's not fair game within the bluffing, puffing, whatever, for me to knowingly make factual misrepresentations to you? Is there a difference there? I personally think so.
If it's a relevant fact,
right.
A material fact, then the rules with regard to truthfulness in the negotiation would apply in mediation. The fact that we add a mediator to the process does not change the lawyer's ethical responsibility with regard to truthfulness.
Okay, good. Let me quickly move to this one, which is hypothetical 6, because we've actually talked a bit about it already, and that's in private caucus, the plaintiff asked the mediator what the value of the case is for an explanation of the law relative to their case. And you've already touched on this a bit, but in the materials you cite on page 43, 44, the preamble 5 to the Illinois Rules of Professional Conduct and Rule 1.2D on the scope of representation and allocation of authority between the client and lawyer. And I didn't necessarily see the connection between the hypothetical and the citation of those rules, and I think it would be helpful for us, Judge, to hear why you included them. And I picked on him because he's the even. She's odd, he's even, just for starters.
We tried to include a lot of what we were talking about in ethical aspects of mediations. The field has not developed so far as a Uniform Mediation Act or ABA rules to really give us a lot of guide work or ground rules. We have some general rules to look at. What we generally try to look at as attorney mediators is what do the rules of professional conduct state we must do? What do the canons say that we do as lawyers? So we try sometimes to, as best we can, try to get one that fits to it. When we're talking about, in this aspect, the value or the law relative to the case, we again use this for the mediator's aspect. What does a mediator do as a lawyer? And if we have not addressed probably in this seminar, and perhaps we can do it another time, what a non-lawyer's ethical rules are during the course of a mediation as a mediator. I contend they're basically the same, but since they're non-lawyers, I don't know that they're expected to know that. We've included these in here because we believe that they are as applicable as we can get one in this particular problem. Again, this goes to the style of the mediation. This is an evaluative situation where people are asked to give values. Very often, by the way, and I hope I'm not getting off the topic, I don't believe I am, mediators are asked to give evaluations or are encouraged to give evaluations as an aid to the attorney, whether it be a recalcitrant adjuster who simply doesn't know what trying a case is like in Cook County or maybe Will County, or whether it's the plaintiff's client, the plaintiff's attorney's client, who believes that the value of the case is much more practically than it is. The aspect about what ethically we can do without telling someone what to do in this situation is, again, the evaluative approach of telling all possible aspects of it. I rarely, if ever, have I given this case is worth and I've given a number. I don't do that. I give all the possibilities. I give all the variables. And I use that to tell them perhaps sometimes what a range is. We'll get into, I hope, if we have a chance a little bit later, the ethical aspects of what we call mediators' tricks, whether they be bracketing, write your second best number on a piece of paper. We play a baseball ball. We play Indian poker. Hold something on your phone. We'll try anything at the end of a mediation to get it done if we possibly can. And again, all within the aspects of what are our ethics as mediators and attorneys.
Can I interrupt? Because I know you just mentioned, I think it's worth asking this question eventually today, this bracketing thing. I mean, when you come to a lawyer and say, okay, how about a bracket of $5,000 to $25,000? Because, you know, you told me that I shouldn't have said $120,000. So, all right, so now I'm down to 5 and 25. Now, when you say that to me as a plaintiff's lawyer, I would assume that you've got $5,000 in your pocket as a mediator, that you already know that. So you're just trying to get me to engage in tit for tat between 5 and 25. What's that bracketing stuff all about?
The facilitative part is where I'm at. When there's brackets, and I do suggest parties go to bracketing, as we'll call it. I don't give my own brackets. I don't tell them what the bracket should be. I explain the process of what bracketing is. And just very briefly, bracketing technically is we are $8 million apart in this case. And rather than spend the next 5 hours in moving in $50,000 increments, you suggest a bracket. The bracket technically can bring you closer together. So the bracket in that case, let's say you were at 8 million and they were at 100,000, you tell a party, pick two numbers. For instance, you might say, if I go to $5 million, I expect you to go to $2 million. Now, technically, what it does is it takes all these little baby steps away. What in reality is bracketing? And you've got to explain this to the parties. In reality, bracketing is everybody looks to the midpoint. So if it's $5 million and $2 million, the midpoint on that case is going to be $3.5 million. If everybody moves dollar per dollar, eventually they'll get to $3.5 million. That's bracketing. Again, it's a way to try to get parties quicker to a point that they want to get to. But what does bracketing do in reality? And I think as a mediator, ethically, you should explain this. If a bracketing is being used really just to save time, nothing more, then you have to say, I'm introducing a bracket. The plaintiff has given me a bracket to give you. But don't misinterpret the bracket. The bracket only means this case will settle anywhere between $2 million and $5 million. And if that's the way the plaintiff wants to do it, then that's the message you give with the bracket. On the other hand, if the plaintiff is in the mind to now let the defense know what they want, and you explain that to the plaintiff in private caucus, that if you give me a bracket and I don't say anything with it, they're going to assume that the midpoint of that bracket is where you want to settle the case. And if you do that, just understand you're giving them this information. And if that's what you choose to do, great, let's use a bracket. And if they say yes to it, they pick their bracket, I don't pick it. I then bring the bracket in there. I say no more. I allow the party to believe because that's what the plaintiff wants me to do. It's the midpoint. What happens in brackets? Then you spend the next 2 hours bracketing back and forth and arguing over what the bracket might be. But it is an effective way to sometimes get the parties at least to know what each other wants.
One question from the internet, and then we'll move on to number 7.
Stephen is asking that if there's multiple defendants, is it ethical for the mediator to continue mediation when one defendant objects and won't participate, but the mediator continues to settle with all the other defendants, and then this defendant objects because he was prejudiced?
Yes.
Again, just to disclose, when you're bringing offers back, and what are the offers? If they're global offers, they're global offers. If they're not global individual offers and you don't bring money back from defendant D, then you're not bringing any money back from defendant D.
And I have a right to enter into a good faith settlement with some but not all parties, so why not?
Can I make just one more comment on the brackets?
Yes, Professor.
Instead of a variation is instead of having the brackets where the parties are trying to negotiate a number in between, we also use final offer, and the final offers from each party are given to the mediator with the understanding the mediator is going to choose one or the other and not something in between. And so it doesn't push them to give you numbers towards the middle. They are now thinking about how does this case sound to the mediator? What sounds reasonable? And so their final numbers end up being maybe 25% or maybe 75%. And my experience with it is once they give those numbers, then I say, you are now so close together. Do you want me to choose one or the other, or do you want to finish this? Almost always, they will finish the negotiation. It's a very useful settlement technique.
So is anything ever final? I mean, you're saying yes.
Yes.
It works. Okay, good. Okay, hypothetical 7 goes to Professor, and that is it's an injury case. And when I first read this, I said, well, why are we talking about this? Does this really happen? And in fact, it does. This is from a reported circumstance, kind of. The mediator learns via the internet that the attorney representing the plaintiff in mediation has been suspended from the practice of law for 1 year, and at the time of the mediation, the attorney is 6 months into that suspension. That's a scenario that, in fact, has taken place. Professor, there's a lot of pages going along with this one.
Pardon? We were talking.
I know you were.
Just that last
We're here to learn. We're all here to learn. Okay. So, number 7, will you tell us what was the mediator's job when she found out that the plaintiff's lawyer is practicing law under a suspended license? What do you do then?
Well, certainly, this is about the clearest HEMO violation that we can come up with. And
Even
again,
Nudelman would report this one. There we go. All right.
and I, like the judge, have never had to report
Right.
a HEMO
But this one's
violation.
pretty clear, isn't it? I mean,
Absolutely.
but this raises an interesting question on a different but related subject, and that is social media and where it's starting to pop up in mediations. Do either of you, as mediators, do any Google homework, if you will, before the mediation about the parties and/or their counsel who are coming before you in a big mediation that you're about to begin?
I do all the time. It's so refreshing. As a judge, I could never do it. I just had to you gave it to me, I read it. I could not do any outside research. As a mediator, I Google things all the time. I Google parties, I Google companies, I Google law cases, I Google federal law when I'm dealing with a federal case. It's very, very helpful. What I do is I disclose it again in private caucus. If it's different than what I've been told in the mediation submission, I've said to the party, by the way, I Googled this, and you saying it happened on Tuesday, but according to Wikipedia, it happened on Wednesday. Help me with this. Explain the situation here.
Okay. Professor, your experience with it? With same thing?
Yeah, I do Google it.
Okay. Are you looking for people lying to you on that truthfulness thing, that 4.1 truthfulness thing? No?
Just getting information.
Just getting information. Okay. All right, now the next hypothetical, in the preparation for this, is there an internet question?
A lot of internet questions. One is asking, what if the mediator takes you aside and says that your advocacy is not helping the progress in mediating the case successfully?
What do they mean by that? Advocacy.
That a mediator, what if the mediator takes the lawyer aside and says that your advocacy for your client is not helping this case this mediation progress successfully? What do you do?
As the lawyer?
My reaction as the lawyer is to say, you don't know why I'm acting this way.
Yeah, I say bring out this standard 6 that says this thing on quality of the process, and then the other on the Uniform Mediation Act, the definition of mediation. Okay.
And also, does the mediator have a duty to affirmatively disclose at the outset a prior business relationship with one of the attorneys, the litigants, its carriers, and should this be part of the preliminary paperwork?
Can I ask you to answer that as part of the next hypothetical, which is a combo of hypothetical 8 and 11, where we're talking about conflicts of interest? with a mediator who works as a partner in a law firm that's either called to mediate a case, or a mediator who's a retired partner in a law firm. Under hypothetical 11, we have old gray head, a retired judge, now counsel to a firm. He's been mediating a contract renewals by a coal company and an electric company for years. This year, the coal company calls up the electric company to mediate next year's contract. They announce that it's been decided to litigate for the proper price at the time. 3 weeks later, the electric company brings a lawsuit seeking declaratory judgment. Who is the electric company's lawyer? Either the law firm, can the mediator participate? There's a whole lot of conflict of interest stuff that we'd like to hear about. Professor.
We have asked Mary Pat to respond to this one.
Mary Pat Benz, our third panelist, expert.
Yeah, I'm pleased to do it. I'll try to be brief. If we're looking at number 8, which is just a general question about conflicts, the reason the mediator is going to look at and do a conflicts check is because of the Uniform Act, Section 9, which requires a mediator to disclose or to make reasonable inquiry about facts that a reasonable person would consider likely to affect impartiality. So it would be an appearance of impartiality or actual impartiality. And those could include financial relationships, past representations, all the things you can understand, social relationships. The Uniform Act also tells the mediator to disclose that to the extent possible before the mediator accepts the assignment to be a mediator. Section 9 also says there's a requirement of continuing disclosure, and this comes up a lot. All of a sudden, the adjuster from some other place whose name you didn't know before the day of the mediation shows up. It turns out that somehow you are related and didn't know that was going to happen.
So what's the mediator do, for an example, when I do some research about Judge Nudelman when he served on the bench, and I realize that my opponent, Katheryn Dutenhaver, was one of his contributors when he ran for the Circuit Court of Cook County? Do I have a duty to bring that up? Did he have a duty to bring it up? I mean, look at all this stuff that's going on now about recusal and everything. Can you speak to that as well?
The Uniform Act isn't that specific. I think those of us who do arbitrations would say that that kind of disclosure, minute disclosure of every single person that you know who's associated with the arbitration is required. Section 9 is a reasonable person standard, and there may very well be facts which the mediator thinks, well, I'm not, that don't cross the mediator's mind, that aren't public knowledge, or that they just don't think is important, that they don't disclose. Now, you and any attorney who's choosing a mediator is likely to do the same Google research that our mediators are doing and say, whoa, wait a minute, I find that unacceptable, whatever that relationship is, and I'm not going to have this mediator on my case.
Well, you know, on a related note, and this is included in one of the papers that I submitted for the materials here, what if I learned these things after the mediation is closed and the case is gone, and now a party wants to say, hey, wait a minute, Nudelman and, shouldn't have been sitting on this. The lawyer on the other side of me was a big contributor. I want a redo. Judge Nudelman, what do you think about that?
And this is a case, actually, that Katheryn found. I'm going to let her to address this. We do have more issues, by the way, if you'll notice. Of all the citations we've given you so far as the rules, this conflict of interest has the most. We've got probably 20 different pages as to that.
And we have 25 minutes left, so let's get to it.
Let me let Katheryn speak to the Facebook case, which is just on that. Information during the course of a settlement conference in this case, and later a party determined that the information was false or erroneous.
And that moves us into question 9.
Okay, please take the floor. Go ahead, Professor.
Okay. The settlement agreement in this particular case was needed a lot of documentation once the mediation ended. That's typical, as many of you know, in a mediation, that what is actually done to memorialize the agreement at the end of the mediation is very brief compared to the documentation that has to take place to carry it out, to implement it. And so the first question that comes up is, who is it that writes out the settlement agreement at the end of the mediation? Often it's not even called a settlement agreement, it's called terms of settlement, memorandum of understanding, principles of agreement, whatever.
Term sheet, right.
And my experience with that has evolved over time. Initially, I would always start that process and write it myself. But I would do it as a scribe. And I would do it saying to each of the attorneys involved, what's number one? What's number two? And once all the attorneys approve of each one, write it down. Not adding any of my interpretation of what the settlement is, but being sure that it comes from the parties themselves. If you do that, and what has happened now is that many attorneys will come to a mediation with their computers. And in a complicated case, it's very helpful to have the attorneys begin filling in the paragraphs and provisions. And there's a lot of downtime in a mediation where the one side is meeting with the mediator and the other one has time. That attorney can be doing provisions, they share it, the other attorney does it. So that when you get to the end of the mediation, there's a real understanding then of what it is that the parties have agreed to, and it's efficient.
Do you advise, I'm sorry.
At first, if the mediator turned it over to the attorneys to do it, and this was back in the 80s, they would have a hard time getting started in the process. And I found it easier if I started the process. That's not so true anymore. Attorneys are much more active in the process now than they were before. So there's an efficiency by using the attorneys.
And that was what I was going to say. Do you advise us that if, in our own work product, going into a mediation, if we really think that it's going to be successful, that maybe we privately prepare, again, work product, an outline of a term sheet that you might have that you can expand on and for an efficient thing? Have you seen that work as an effective tool by lawyers?
Absolutely.
Yeah.
And the concern is to get enough into the term sheet so that you do know what is going to happen with the documentation and the settlement doesn't fall apart because too many things were left over.
Judge?
If I could just say a few more words on conflict and, again, disclose. Katheryn and I have both walked into mediations where we've been given the names of the parties, we know the attorneys, we know the CEO's name, everyone. We walk in there and there's someone sitting at the table that we went to high school with, and we just didn't think about it. And again, what do? I don't do a wave like this, I disclose. And I let the parties know, by the way, this is Susie Schwartz, we went to high school together 50 years ago. What would you like to do? I'm not a judge anymore. As a judge, I can say, and I can be fair, so let's continue. I'm not. It's a private mediation. You make the decision whether or not you think that I should remain on the case. You might want to question me about it. You might want to talk. But again, disclose to both parties. The aspect about conflict of interest is very, very significant in the mediation. And the reason is for what Bob said. It's to protect the quality of the process. If at the end of the mediation, you felt that, in fact, it was fair, but later found out something occurred, and now you're thinking, I wonder if these negotiations really were fair. I wonder what happened in that room in private caucus. Now that I found out the judge, the lawyer gave the judge $10,000 in one of his campaigns. So again, disclosure is important, and even if you don't know the information before the mediation, if you find out it during the course of the mediation, disclose it.
A question from the web.
Yes, we have several people. Mark, Richard, James are all asking, can a mediation be conducted with only one side paying for it? And if so, does it affect the impartiality of the mediator?
Anna. So now, I apologize. So mediation, if one side, why would one side pay for it only? Do you have that happen?
There are
what
some
happened?
cases where insurance companies will pay the cost of the mediation in some smaller suits, or they'll pay the cost if the case settles. If the case doesn't settle, then both parties will pay the cost, or vice versa.
Is that the norm, though? Like that just so we're clear about that, You split 50-50 the cost of the mediation?
That's the norm.
That is the norm, okay.
Yeah.
All right, we have a,
I think that if the other side, the one that's not paying, comes with counsel, they're paying counsel. It isn't that they're not making a commitment to
Right.
the process.
Sure.
And the other part to that is you don't want the one who has not paid any of the fee to feel they are not welcome to really participate. So you don't want the imbalance either way.
question from the floor?
If you're the lawyer who's made the donation to Judge Nudelman's campaign, don't you have an obligation, an ethical obligation to disclose it?
Well, what do you think, Leslie?
I think you do. But I mean, it goes to not only, the point is not only does the mediator have an obligation, but each lawyer has an obligation. And if you find out later that the lawyer hasn't, then what?
No, on a serious note, though, so the question is, Nudelman, and I'd have to check records if in my case, okay? So if I made a donation to his campaign when he ran, and I didn't remember that going into the process, so is Nudelman telling me today, and are you telling me today that I should, hey, by the way, I just remembered that in 1998 when Nudelman ran for office, I donated that $10,000 to his campaign. Is that my ethical duty to do?
That's my question.
I got the ethics experts here. What's Mary Pat say?
I wouldn't.
The answer is yes. Disclose, don't you
The
think?
answer is yes. Disclose while the mediation's going on. But
Right.
there's an end point. Just like there's an end point about disclosing to courts what might have come to your attention long after the case is over. And I think there's an end to mediation disclosure as well. And so now you could mediate in front of a judge who you had donated to his campaign years ago, and you didn't know, and case settles, then let things lie. I think is a perfectly ethical.
And by the way, we're looking at this from 2 points. We're looking about this. There's certainly doing that. There's no ARDC beef here, so you don't have to worry about being prosecuted. But again, we're looking at your reputation as an attorney and your reputation as a mediator. And while there may not be a problem with the ARDC or the Judicial Inquiry Board if you're still an active judge doing pre-trials, whatever it is, the safe thing to do is let the parties know the information you have.
Another question from the web, and then we'll move on to another hypothetical.
Yes, is it ethical for a mediator to recommend a structured settlement?
Why not? Okay, is it ethical why not?
I do it all the time. If I have a case where there is a young child who's been injured and his parents are not sophisticated financially, and there's about to be a huge settlement on this case, I've always recommended that they should seriously think about a structured settlement. I don't know enough about it to talk specifically about it, but usually the attorney does, and I've always recommended it.
Katheryn, same for you? Same answer? Okay. Hypothetical 9, we all found this one interesting, I think, when we talked about it, but is it really, you are participating in a mediation. The mediator is holding a joint session so that each side can tell the other how outraged it is. The presentations are being made by the clients, and your client, despite your careful preparation of her presentation, blurts out, "Our case is so strong, we've been able to get Professor Stapleton, that renowned Nobel Prize winner, to be our expert witness." Well, the good professor has never been approached by your client or by you. So is that, what's the scoop there? Number 9 would be, Professor, we begin with you.
The question is whether the lawyer has, under the obligation of truthfulness, does the lawyer have an obligation to correct an untruth that was said by the client? And if it's going to impact on the negotiations with the mediator, then I do think the lawyer has the obligation to correct that.
Why isn't that any different than that puffing stuff that we said was kind of okay?
Well,
Because number one, the lawyer didn't make this remark. The client blurted it out, and clients do such things.
That's right. But when the lawyer lets it sit there, then the other side is assuming the lawyer's endorsing.
But the lawyer made the observation that remark got some traction by the other side.
Right.
And
the other part is we have to analyze it on whether or not that's material, a material fact for which we have to be truthful.
And that's 4.1 of the Illinois Rules of Professional Conduct. page 67 of our materials.
Right.
And it also fits into the Rule 3.3 on candor towards the tribunal. But is this really a tribunal? Is mediation considered to be a tribunal? Does Rule 3.3 actually apply to mediations? Judge?
I know that Rule 4.1 does.
Yeah. I'll take that as a no.
I don't think 3.3 does.
3.3 does in your, okay.
Because the mediator's not making the decision.
Okay. How about we take another question from the web, please?
Yes. Is it permitted to have a mediation turn into an arbitration if the parties agree?
Sure.
As long as the mediator is convinced they know what they're agreeing to. And also, I would put that in writing to give them a chance to really think about it and the attorney sign off on it.
Okay. Another question from the web?
Yes. What if in the case of where it's a large number of parties, 20 to 30 of them, and it's apparent that some of the parties have nothing to do with being at fault? Can the mediator get involved in terms of what do you do about getting rid of the other parties?
That very often happens in construction defect
That's
litigation.
what it's asking in particular construction, for an example, construction defect case.
Construction defect litigation, very often you'll have the condominium association that sues the developer, and the developer then sues all of their subs. There may be 20 subs or 30 subs. Some of the subs may be involved in mandatory arbitration. Some of the subs may be via a lawsuit in a circuit court. What a mediator will do in that situation, even before the plaintiff appears, very often the mediator will meet with, again, it's a mediation, not an arbitration, no such thing as ex parte. The mediator may meet with the LLC and may meet with the general contractor and try to determine how we can progress to get an offer for the demand being made to repair the facade of the building because it's leaking. And what the mediator does, what I've done in those situations, you have separate mediations with the separate groups of parties. You then, certainly it comes to exist that the person who laid the foundation for the basement has nothing to do with the balconies leaking on the 14th, 15th, and 16th floor. Eventually, the LLC may come to reason and dismiss that party, or perhaps collect nuisance value if they choose. Again, not my affair on that, and get parties out so we can get the mediation to be more tenable, or one that you can work with in size. So a mediator certainly can do that and should do that.
Okay, question from the floor. Pat, could you pin that? Thank you. Judge Metcalf.
Yeah, the problem with the meet-arb situation is that in many cases the mediator will get private information from each of the sides, which he wouldn't get if he had to decide the case. And here you're putting him in the position, or her in the position, of having to decide with having received information, which may be what the bottom line is from either client. So,
but the question assumed, though, Katheryn, that we agreed, and so to me the query is: is there a point in time in which, even though the parties may agree, that the mediator has an affirmative duty to decline the opportunity to convert to an arbitrator? And where's that line at, if there is a line?
you have I believe you have the obligation to decline when you have received information. On the other hand, if both parties agree, knowing that you have received that and you've made that clear that you have received information from both sides or one side that may influence your decision on it, then the parties understand it, and you're relieved of your obligation to decline.
Yeah, Judge, I don't want to let this one go, though, because, and Katheryn, please bear with me, but being former head of the Domestic Relations Division, I feel it's fair to ask you this. There's a lot of talk about arbitration agreements becoming part of marital contracts, and that when you're asked, isn't there a disparate, no matter what, isn't there a disparate relationship when you go from someone trying to mediate a domestic relations dispute, let's say a marriage, and then all of a sudden you're being asked to be an arbitrator? Are you just incapable of doing that?
You may be swayed by what you have heard before, and I believe you do have the right to the obligation to decline, But if the parties understand it, and the only problem there is that in many cases the parties in the mediation are not represented by attorneys.
Right.
They will go in individually, feeling that they know what they want to do, and also they don't want the extra cost of having their attorneys present. So.
Thank you, Judge, and thank you, Professor. Go ahead. I apologize for the interruption.
I think asking the parties if they are okay with you turning into the arbitrator, and they say yes, that doesn't mean the mediator doesn't also have to use their own professional judgment. And even if they both say yes, there could be circumstances where the mediator will say, I cannot do it.
Okay. Right. Hypothetical 10 then. At the conclusion, we've kind of touched on this, and it's actually maybe a great hypothetical to end with. At the conclusion of the mediation, the parties agree that the mediator is going to draft the agreement that has been agreed to orally. To begin, A, should the mediator really do that? And then B, now assuming the mediator does, and then one of the last sticking points in reaching an agreement was a non-compete clause, and your client refused, the other client insisted. Your side collapses. The mediator then sends around the agreement to each side to be signed in counterparts. Your adversary faxes his client's signed version to you. You, in reviewing that side's signed version, realize the mediator omitted the non-compete clause. What do you do? Judge, number 10.
I never write my own settlement agreements. I am the scribe. I really sit there with a pen and I say, what would you like me to write? I never use my own language. It's not my settlement agreement, it's theirs. All I am using is my handwriting, printing, or my laptop to write it up, and they agree to it. If I see that the second part of it happens, I will assume they mistakenly sent the wrong document, that they simply made a mistake. I call back the attorney and say, I remember that we agreed to the non-compete. You sent one signed by your client without the non-compete. Will you please have your client sign the one with the non-compete? If the attorney says, no, Judge, you're wrong, that's not what happened, I call back the attorneys together, and I put them in a room, I sit there as the referee, and I have them talk to each other. If I truly do believe, and I know, because I signed it, that it was with the non-compete, our original term sheet, and that's what it was.
But on a related note.
By the way, if I believe that the attorney has done this purposely, and it wasn't an accident, where we really are back to him.
Yeah. Judge, here's a question I have, though. I've seen this circumstance where the parties knock out what they called a term sheet, and let's say it was a 10-point term sheet. Then they use that document as a way to further fight. In other words, they went home that night, they had this 10-point term sheet, everybody signed off on it, and then the following day, there's buyer's remorse or payor's remorse, and now there's a dispute. How do you solve that? Would the parties be wise to include a provision that allows the mediator to be the arbiter of a dispute in the meaning of a term?
That's being done increasingly.
Tell us more.
And the concern that I have about it is that at some point you have to say there wasn't really an agreement. If they really disagree afterwards, and I'm the one who has to decide that as an arbitrator, then was there really an agreement? So I think it's dangerous to go there automatically and say the mediator is going to do that.
Yeah, but somebody's got to, because someone's going to say the following morning there was no agreement and that term
But I've
free,
had cases
and the
where
deal's
they've
over.
then come back to another mediation conference and they have settled.
Or this is simply a contract that now goes to circuit court to be enforced.
Okay. Question from the web?
Yes, lots of them still, and we only have a few minutes. What tricks does the mediator have when the defendant offers a reasonable amount of money and the plaintiff seems interested, but the attorney for that client maintains a much higher hard line?
You're smiling, Judge. You're the
I may have an idea what I think is a reasonable offer based upon experience or based upon the facts that I've read. I bring that offer. I give it to the plaintiff's attorney. The plaintiff's attorney simply doesn't want the offer. Again, this is tempting. to try to go to the plaintiff directly and saying, this is a great deal, you should take it. I don't do it. None of us do it. It's not done. This is the scenario we read about where the mediator gets much too involved in the process and then starts to think for the plaintiff or for the plaintiff's lawyer. Again, I don't know why the plaintiff's motive, what the plaintiff's lawyer's motivation is. It may be something I have absolutely no knowledge of that's affecting his interpretation or value of the case. I have to stay out of it.
Have you ever mediated anything over the phone, and how does that work?
Very often mediations don't end that day. The parties are thinking about it. I'm probably involved right now in 6 telephone mediations, trying to conclude a mediation over the phone by just trading phone calls back and forth, and a lot of them settle with phone calls.
Professor, I'm going to ask you this question, and Judge, I want you to think about it because I'd like your answer as well. So now we've been here. It's been a lot of fun, and I'm so grateful to both of you for what you've done, and also Mary Pat Benz and Judge Makoff for weighing in here. Professor, if you had one tip that you wanted to give us all, that when you came here you said, I got to make sure I communicate that one tip to everybody here, what would it be? And everyone on the web. Go ahead.
This is from the attorney's point of view or from the mediator's
Yeah,
point of view?
from your point of view. You've been from Professor Katheryn Dutenhaver's point of view.
I think the most important thing that goes on in a mediation is for the mediator not to interfere with what's happening between the lawyer and the client. And this has come up a lot today at different places. But I don't think that we serve the quality of the process by interfering. I don't think we serve that particular client and attorney by interfering.
Okay. Judge?
It would be more or less an advice to an attorneys, and that's prepare for mediation. You would not dream of walking to a trial unprepared. Why would you ever go into a mediation unprepared? You go to trial to be successful, to get what your client needs. You should be going into a mediation for the same purpose. The preparation should be key to your mediation.
Is there a single biggest mistake you've seen lawyers make, Judge, in all these mediations you've done, and then end with you, Professor, because you're shaking your head, yes?
If the mistake I've seen is not having the people at the mediation who can make the decision.
Okay. Katheryn?
And not being prepared. It is treated differently than going to court by a lot of people. Not so much anymore. That used to be much more prevalent than it is now.
When I was a first-year lawyer, I walked into the chambers of Judge Philip Fleischman, and he had a sign above his door. It said, "Preparation is the byword of all that pass through this portal." So, ladies and gentlemen, both here and on the web, a great thanks to Professor Katheryn Dutenhaver and to Judge Stuart Nudelman. So, thank you so much. We'll see you all next year. Thank you very much, everyone.
Thank you for attending today's program, Ethical Issues in Mediation. Please be sure to fill out and submit the evaluation form that can be found by clicking on the Evaluation tab, or you will be given one as you walk out of the room. Certificates of attendance will be emailed within the next few days. From Clifford Law Offices.